Hi, welcome everybody. Welcome to Boulder County Senior Law Day 2021, the day that lasts just over a month. We are here for today's presentation on elevated estate planning with Sarah Pheral. Before we get started, I am going to go ahead and go through some logistical details to make sure we're all on the same page, because webinars, see a question already pop up in the chat about follow-up questions. So you can certainly contact us with follow-up questions. I believe probably the best way to do that will be through the website, but I will poke around during the webinar and try to get a more concrete answer for follow-up questions after the session ends. So obviously we are in a virtual format. This is our second year in the virtual format. We're hoping next year we'll get to be in person. We're really looking forward to that. But the advantage of being in a virtual format is that today's webinar is being recorded. The video will be available later on Boulder County Senior Law Day's website and our YouTube channel, and I'll post those links in the chat. The host has muted all participants. Please remain on mute for the rest of the webinar. If you do have questions during the presentation, please put your questions into the Q&A or into the chat box. Our speaker will let us know when she is ready to invite questions. We have some really good upcoming webinars coming up next week. Tuesday, I believe, is going to be on Medicare fraud. So that'll be really, really interesting, definitely an important topic. And then next Thursday, our district attorney, Michael Doherty, is going to be speaking to us about elder abuse. Really wonderful, substantial topics. You can sign up for any of these topics at our website, bouldercountyseniorlawday.org, and I will be posting that link in the chat as well. We're also really excited that this year we are able to offer in-person Ask a Lawyer. We just had the Longmont event, and the Boulder event is coming up, not this weekend, but next weekend, September 25th. It's going to be at the Boulder Agewell Center at 909 Arapahoe from 9 to noon. Masks are required because it is indoors. But it's a really good opportunity to get a free consult with an attorney. I will say, based on the turnout in Longmont, we didn't have any waiting time. I think the most anyone waited was about 2 minutes to get their form filled out. So please come to that event, spread the word. If you know anyone who has some really pressing questions, we're going to have attorneys with a lot of different practice areas ready to advise folks. If you are unable to make that, our platinum level sponsor, the Boulder County Bar Association, is still running a virtual free legal clinic. This is a clinic where callers will sign up either through the phone number or through their website. And you'll get matched with a volunteer attorney and have a brief consult with that attorney. We have Senior Law Day handbooks. I have been assured that the 2021 Senior Law Day handbook is coming out real soon. When it does, it will be available at this website. In the meanwhile, the 2020 version is at this website. And we have a QR code that will take you directly to that website. So if you have your smartphone handy and you're watching this on a bigger screen, you can just wave your phone in front of that code and go directly to the handbook, which you can either download or read online. And finally, we'd like to thank all of our sponsors, our platinum level sponsors, the Boulder County Bar Association, Pearl Fiduciary, and Fraser. Our gold level sponsor, Jorgensen, Brownell, and Pepin, our silver sponsor, Hofgard and Bach Financial, and our bronze, Kingsbury, Johnson & Love, and Friends of Longmont Senior Services. And with that, I am so excited to introduce our speaker today, Sarah Pheral, to talk about elevated estate planning. Sarah is the principal attorney of the law office of Sarah Pheral in Longmont. Her firm helps clients simplify life's legal complexities by providing quality legal services with integrity and compassion. Her staff assists clients with business law needs, drafting and using estate planning documents such as powers of attorney, wills, trusts, and medical directors, probate and trust administration, guardianships and conservatorships, and more. And Sarah also serves as a professional fiduciary. I should also say Sarah used to be our chair of our planning committee back when we had to do the hard work of doing this in person. And I have firsthand gotten to observe her compassion and her dedication to community service and community education. So with that, I will turn this over to Sarah, and I'm really excited to learn from you. Thank you.
Thanks, Brett. Brett, are you seeing some weird green line on my screen?
I am not. Your screen looks good to me.
I'm going to ignore it. Hello, everyone. My name is Sarah Pheral, and I'm trying to make sure we can, there we go. All right. I do have an office in Longmont, and my practice consists of business law for small business owners, as well as the estate planning, probate, and elder law, as Brett mentioned. And I am talking today about elevated estate planning, which we are looking at as basically advanced estate planning, or estate planning 201. So I'm going to assume that you know basic estate planning already. If not, please definitely attend the estate planning basics, and feel free to come back to this material after you've got the basics down. Hopefully this will make more sense. I'm a lawyer, sorry. So there's a disclaimer. Our discussion today is for informational purposes only. You do please need to discuss your personal situation with the appropriate experts to receive advice based on your values and your goals and your specific circumstances. And I will tell you that I am not planning on answering a ton of questions today, because the material that we're covering is so complicated. It's hard to make generalizations. That said, I am going to tell you what you need to be aware of and consider based on your specific circumstances. Okay. So first things first, you may be asking yourself, do I really need to be here? I can tell you, I hear these two sentences very often, or some variation thereof. My situation is very simple, or our plan is really straightforward. And then I look at the questionnaire and I ask some questions, and I have definitely seen some very simple and straightforward estate plans in my day. I will tell you they are the exception and not the rule, because most of us live relatively complicated lives somewhere or another. Okay, so here are some estate planning flags that I came up with, which indicate that yes, you need to be here. First, you want to leave assets to people who are not your legal spouse or your legal family members. You want to exclude people who are your legal spouse and family members. All of the people that you would want to appoint as your agents or your personal representative or your trustee are your age or older, or you have none at all. You have a spouse with or without children together, and children from a previous relationship. You own real estate interests in some other states, or you expect to inherit some. A beneficiary that you plan to give something to has an addiction, or may need Medicaid for long-term care, or they may have a disability. I've also seen several times you have an animal who is likely to outlive you, who needs substantial caregiving, such as a horse or a parrot. These are additional flags that come up a lot. I'm a millionaire. I have extensive land or agricultural assets. I don't want the government to end up with it. I have one or more businesses. I want privacy. I don't trust my appointees to do what I want. I don't trust my appointees to be fair to the rest of my beneficiaries, or we want to avoid probate. I also hear these a lot. I'm going to address each of them. If you are a millionaire, I want you all to know that the 2021 estate tax threshold is $11.7 million per person. If you are married, you can split your asset ownership in such a way that you are over 23 million before your estates become taxable. I can tell you that none of my clients have a taxable estate. If you do need estate tax planning along with your estate planning, I highly recommend that you hire a lawyer and someone who specializes in estate tax planning, because as you can guess, there aren't a ton of people who hit that threshold. If you have extensive real estate, yeah, you probably do need some higher level, more intense estate planning. I don't want the government to get it. That's only going to happen if you have no living family members to be found. Otherwise, it's going to go to somebody. It may not be who you want it to go to, but it's not going to go to the government unless literally no one can be found. If you have businesses, you probably need some advanced estate planning, either on the business side or on your personal estate planning side. I want privacy, and that's a legitimate concern. And for example, doing a trust instead of going through probate with a will, that does give your estate administration more privacy. But the flip side of that is the next one. What if I don't trust my appointees to do what I want? If you got a trustee, for example, just to avoid probate, it's very difficult to get to hold that trustee accountable because it's not going through the court system. So there are two sides to that coin. Yeah, and if you don't trust your appointees to do what you want, that's a problem. You should discuss that with somebody. Similarly, if you don't trust your appointees to be fair to the other beneficiaries, also a problem. And if you want to avoid probate, I'm not saying that that is a right or a wrong answer. I don't believe that there is such a thing as right or wrong wishes when it comes to planning what you want to happen later in your life and after your death, but when people tell me they want to avoid probate, my question is why? And sometimes I hear very legitimate answers to that question. And a lot of the time people just think probate is a super scary, expensive, terrible thing. And I can tell you that in Colorado, that is not necessarily the case. It certainly may not be worth the cost and administration required to have a trust and put all of the things into the trust. We'll get into that a little more later, excuse me. I like to go over this with everyone because there's a lot of misunderstanding about how property passes when we die. And there are basically three ways. The first is by title or property law. So when people own something with someone else in joint tenancy, or if they have a beneficiary deed recorded for their house, there's certain types of ownership. When a person dies, the surviving owner just takes the property outright. That does not go through probate. Your will cannot influence that in any way. Typically, the survivor has to provide somebody with a death certificate, and it gets processed one way or another. So that's the first way that property passes. The second column there is by contract. So when we're talking about by contract, we're talking about life insurance policies, retirement accounts, potentially survivor benefits. If you've set up a payable on death or a transfer on death for certain accounts, or if you do have a trust, basically all of these different tools and methods are contracts. So for example, when you fill out a beneficiary designation form with your life insurance company or whoever's administering your retirement account, they are saying to you, if you fill out our form, when you die, we will do what the form says. You're creating a contract, okay? So all of these items as well, unless the designations fail for some reason, these items are all going to pass by contract and they are not going to go through your probate estate. And that's important because a lot of people worry a lot about their will, and many people, their will doesn't have a whole lot to do with anything. because so much of their property is passing in those first two columns. But sometimes that's not the case, and your will matters very much. So the things that go through probate are any other assets that are owned in the deceased person's name alone, or if you own things as tenants in common with somebody, which means you don't own them together jointly. You don't own the whole thing. Like a married couple often owns their house jointly and maybe their bank accounts. Maybe you go in with your sibling or someone else to buy something together and you each own half, or three of you get together and go in and you each own 1/3. If you die, your fractional interest in that property has to go through probate, unless you've made some other arrangement for it. So that is how property passes. I'm just taking a look at the chat to make sure I'm not missing any questions so far. Okay, so I want to note this slide has to do with probate assets only. So again, if things are owned jointly, or if there's some form or contract or agreement of some kind in place, I'm not talking about those assets. So this slide is about intestate defaults. And intestate means there's no will. So who is an heir? If I die today and I have no will, what happens to my stuff, to my probate assets? So first, if there are no children or all of the children are children of two spouses and there's no surviving parent, the spouse takes 100%. Okay. If you have a spouse and kids from a previous relationship, the estate is split. If you and your spouse have kids and spouse has kids from another relationship, your estate is divided. If you have a spouse and a surviving parent, your estate is divided. A lot of people don't recognize this. They just think, oh, my spouse is going to get everything. And that's not always the case. If you have no spouse and no surviving parent, no spouse, then it goes to your descendants. So your children, or if one of your children has predeceased you, it might go to grandchildren or on down the line. If you have no spouse and no descendants, but you have surviving parents, your estate's going to go to your parent or parents, whoever has survived you. Otherwise, it's going to branch out, and they're looking for your closest family members. So if you have siblings, they're going to take. If you have nieces and nephews, they're going to take. If there's no one in that group, they're going to look farther out. What about cousins? So as I said before, it's pretty difficult for an estate to end up going to the government, because usually we can find someone who is related to the deceased person. Your estate plan, I want you to think about it like a machine, an old-fashioned machine, not the electronic ones that we have today, because I find those are even more confusing. But think about it like a clock, with cogs and all these moving parts. Your estate plan consists of a set of documents, and it includes those non-probate transfers. So we're looking at everything when we look at an estate plan, not just a will, not just documents. We're looking at what have you set up for your accounts, what beneficiary designation forms do you have in place, and what don't you. Sorry about that. I didn't realize something was on. Okay, so we're looking at all of the documents, and they all need to be consistent and coordinated. And it may be that you are capable of doing that by yourself, and that's fine. But you just need to know, that your will and your powers of attorney and the things you do during your lifetime with how you own your assets, the beneficiary designation forms you fill out, all of these things need to be up to date, correct, and consistent. Or you will potentially, you won't, but somebody will run into difficulty after you pass. You do need financial and medical powers of attorney, period. And I'm going to say this to you throughout this presentation because I feel that strongly about it. Most of us during our lifetime, for one reason or another, find ourselves in a situation where we are either not able to manage our finances or we are not able to make medical decisions for ourselves. And that's what a power of attorney is for. It is to appoint other people to step in when needed to manage your finances or to help you with medical and residential needs. You absolutely need those. For all of the documents, I want you to really think about what that person needs to be doing and who is the best person for the role. Honestly, it might not be your spouse. It might not be your oldest child. It may not be any of your family members. One of the examples I use a lot is, for example, if you are adamant, I don't want to be on life support for the sake of being on life support, well, probably don't ask, your very devout Catholic sibling to be the one to pull the plug, because they may struggle with that on a personal level. All of your agents need to be able to do what you want done. That's what they're supposed to be doing, is following your wishes. But also, when you're thinking about a medical agent, you're thinking about somebody who can really assess what you would have wanted and make a good call in any given situation. In the financial roles, in addition to that, you really want somebody who's good with detail, organized, honest, fair, because they're dealing with running your life and your finances and your assets. I will tell you, you cannot have too many backup appointees for your various roles. If you have them, put them, because people get sick, people die, life happens, and they just aren't available. So if you can put backups, keep them coming, because if the documents fail, there are ways to deal with that, but they tend to be complicated and more expensive, and you don't know who's going to end up in control at that point. It may not be someone you would choose. You do need to understand what your documents do and don't do. And if you are not sure, find out. I've experienced a number of situations where people thought their documents did something, and their documents definitely did not do that. So you want to make sure that you understand your documents, at least at the time you sign them, even if you forget all about it later, until you need to think about it again. Okay. So these are some common problems that we see all the time. And, I really try to help people think about the logistical issues involved with making their documents work, because again, so many times I see them not work. So here are the things that come up most often, when somebody's had an unexpected accident or illness, or they've died unexpectedly. People don't know, are there documents? They don't know where they are. They don't know who's appointed. They don't know how to contact distant relatives or strangers, just people they don't know throughout the family, or friends of yours. They don't know what assets there are. They don't know what bills there are. They don't know how to access your computer or your iPad or your phone, or where your password list is, or if you have a password list, if you do anything online, if everything comes in the mail. And even when they have documents and some information, especially when people do their documents on their own, what I see happen the most is, people asking, well, what did they really want done? Did he mean that? And I see situations where people go, I'm pretty sure they didn't mean that the document says. I'm pretty sure they didn't mean that. Well, that's what the document says, though. Okay, so now what do we do? If everyone's agreed that, Joe didn't mean what this document says, well, okay, how do we fix it then? And the other problem we see is, I can't do what she wanted. Now what? Okay. So think about alternatives. If there's something you'd like to happen, but you don't feel that strongly about it, put it in the document so your people know. It's not the end of the world if this doesn't happen. If this can't happen, do that instead. And then they don't feel so bad if they can't make it happen. One of the things I promised to talk about is excluding people. Obviously, it has to be put in your documents. You can't just ignore the fact that you're cutting out a kid, for example. You do have to put it in the documents, but you do want to be nice about it. There's some nice language that we often use when we draft these documents, to make it clear that, I have this child, or I have this sibling, or whatever, and that's great. And I am purposefully not including them in this, et cetera, et cetera. You don't want to just go off and explain why, is what I'm trying to tell you. Now, one thing you do need to understand is about spouses. and this comes up a lot with blended families, especially where people have children from previous marriages. You cannot exclude a spouse unless you have a valid marital agreement or you get divorced. Those are the two ways. And your divorce has to be final before you die. If you die while your divorce is in progress, your spouse will still have rights to your estate. So that's something that, if if your spouse is independently wealthy, they don't want any of your money, they want to, they agree it should all go to your children, that's great. Get a valid marital agreement in place, make the arrangements. Anybody else can be excluded. People sometimes worry, they've got a brother or, an uncle or a niece or something that they're concerned might have some right to their estate. And, if you have valid documents in place, they have no case. And that's not something you need to worry about. You may need to take extra precautions, depending on your situation, to ensure no one can reasonably argue that your documents are the production of fraud or duress or undue influence. So if you, for example, are, perhaps you have mobility issues, for example, you can't hear very well, you ask your child to call my office to set up a consultation, at some point, we are going to want to talk to you without your child present. It's not that we don't like your child. It's not that your child, we think your child is up to something that they shouldn't be doing. But, as attorneys, we have ethical requirements to make sure that our clients are not being influenced, by another party, that what we're doing is what our clients really want to be doing. And so a lot of people don't understand that either. The family are trying to be helpful, and that's wonderful. But at a certain point, we're going to need to talk to the client or the clients alone to make sure that this is really what they want done, that they really understand what they're doing, that sort of thing. And if you're in a situation like that where you think, your kids don't get along, one of your kids is helping, the other kids are going to argue it's undue influence or something, at that point, your attorney may want to record the execution ceremony or get a doctor's note saying, this person has full legal capacity or something along those lines to help bolster the validity of your documents. And as far as excluding people, you need powers of attorney, period. If you do not have powers of attorney and you are in a car accident and just stuck in a hospital bed somewhere, you have no control over who ends up being, if you need them, your conservator and your guardian, unless you come to and can say something. You need powers of attorney so that it's clear who you want to step in during your lifetime, if you need help with your finances or with your medical decisions. All right. Next, I want to talk a little bit about non-traditional plans. So your solutions, your strategies, that's going to depend on the details. So here are some things I commonly see that I consider sort of non-traditional situations. Do you consider yourself common law married? Are you not married but committed partners? Are you appointing somebody or giving something to an ex-spouse? Do you have stepchildren or other people with a very close relationship, but it's not a legal relationship, but you want them treated as family? These are all non-traditional situations and they come up frequently. Again, you need powers of attorney, period. That's how you get the people you want doing the things you want done and not someone else. When it comes to these non-traditional plans, again, it's very much dependent on the details. I can't tell you, oh, just get a trust or do this or do that. It really depends on what's going on and what you want to accomplish and what specific complications there are. Depending on what's going on, a will may work just fine. Depending on what's going on, a trust may work better. There are some things like with common law marriage, or say you're one of those people who, for whatever reason, has a dozen AKAs and every account and every asset has a different name on it. You can use a sworn affidavit to clarify some things So you can use a sworn affidavit to say we are common law married, so that you have something that you have both signed while you're alive. You can also do the same for your AKAs. You can have a sworn affidavit saying all of these AKAs, that's all me. Okay. And some of those things really help, when you've got those complicated situations. I also wanted to mention that Colorado does have something a little unique. It's called a designated beneficiary agreement. I have never met a client who knows what that is. And it's a really interesting tool because typically under the law, there are certain rights that only a spouse can have, right? And this form, it's called again, a designated beneficiary agreement. You can actually designate a person to have rights that only a spouse would have. Okay, so this could be your committed partner. It could be a sibling. I don't know, I'd have to look again, but last I looked, I didn't see any limitation on who can be part of this designated beneficiary agreement. And you can pick and choose. You don't have to choose everything. You can pick and choose certain things. So that's a very handy tool depending on your situation. So blended families you may also consider non-traditional, but what I mean by a blended family is we've got spouses and they have children from previous relationships. One or both of them have children from previous relationships. Perhaps they have children together. And so again, your solutions and your strategies are going to depend on the details. Are you common law married with kids involved? Are you married with children from other relationships? Are your children grown or are they still minors? Do you have maintenance or child support obligations from a previous relationship? Do you have plans to exclude someone or to make, I should say, unequal gifts, I think. Unequal gifts like among your children, perhaps. Do you have plans to have an ex handle some things? That actually happens a lot when people are divorced and they have a child together, and perhaps the decedent really doesn't have a lot of family and the only heir is that child. A lot of the times the ex-spouse ends up being the one who has to open probate and administer the estate so that everything gets to their shared child. And some people actually get along really well with their ex, and maybe they don't have any other kids, and maybe they do want their ex-spouse to handle things on behalf of their children. And that is totally possible, but it's best that you get that set up officially. Again, you need powers of attorney. These situations too, it depends on the specific circumstances. Depending on what you want to do in the circumstances, a will may work just fine for what you're trying to accomplish. And especially with blended families, a trust may work better. For all of your planning, I highly recommend that you communicate plans in advance to minimize conflict later. If people know what's coming, they are much less likely to get into arguments about it when the time comes. And if they still get into arguments about it when the time comes, my take is they were never not going to get into arguments when the time came. You've given them plenty of time to get over it and they still haven't. You've done all you can. But you definitely should let people know why they are not going to be in a certain role or why you are doing something unequally among your beneficiaries and that sort of thing. It just helps people, even if they don't like it, they know it's what you wanted, right? This comes up a lot, especially in Boulder County, but honestly all over. What if you have no good options for your agents and your PR and whoever it is that you need to appoint? Well, if you have no agents at all, or your powers of attorney fail, maybe you only had one person listed and that person died or they're sick, somebody is going to need to go to court and be appointed your guardian and your conservator if during your lifetime somebody needs to take over everything. Now that person may not, again, be who you wanted, and conflict may ensue and it may cost a lot of money. And if there's no one to do that and you don't have a lot of assets, well, then what? I mean, depending on the situation, you're becoming part of a system. You don't know who's going to be taking care of you. If anybody's going to be taking care of you, it can turn into a really nasty situation. There are options for professional fiduciaries. If you have sufficient assets, you can use a trust bank or a trust company. And then there are also other companies and individuals who will serve in these roles. Now, I will say, and I haven't heard anything about it lately, I know Denver Metro was doing a pilot program for a public guardian in order to deal with, those tragic situations where, people who need agents or they need a guardian and they need a conservator and there's no one, for there to be basically a government agency with an office that those people step in and take care of those people. They become their public guardian, right? But last I heard, that's only in Denver. I don't know if it's going to be expanded. I don't know if it's going to continue. Most states do have something like that in place. But Colorado, their program is in progress. If you think that you need a professional fiduciary, or if that's something you want to discuss, I highly recommend taking a look at the Colorado Guardianship Association website, and the link is there. They offer resources and they have a member directory I really like because you can sort by role. You can look for attorneys who specialize in these sorts of things, financial and medical fiduciaries, and there's some other resources there as well. I will say that the people who are in their directory, it's members of the Colorado Guardianship Association. These people aren't necessarily vetted, or they don't necessarily have certain qualifications, but it's a starting point. And I would highly recommend, if you need professionals, interview them, ask questions, before you select one. At least talk to a few people. Okay. I wanted to go over Medicaid planning just a little bit. I'm assuming that we have a Medicaid planning course this year. We usually do for Senior Law Day, but I'm going to just touch on it. What you need to know about Medicaid planning. I am talking about someone who does not have sufficient assets to private pay for in-home care or a nursing home. Okay. And at some point, their assets are going to dwindle to nothing, and they're going to need what we call Medicaid for long-term care. Okay. So when you need Medicaid for long-term care, Colorado actually has a 5-year look-back period. Okay, so they're going to look back 5 years through the person's financial transactions, and they're going to look for transfers made that were not made for fair market value. And a lot of people have a lot of ideas about what that means. And I'm going to suggest to you that the definition is probably broader than you think. Problematic transfers, gifts, obviously, including valuable property. Medicaid doesn't care about your personal property. They don't care about your wedding rings. They don't care about those kinds of things. But if you're giving away, $100,000 RV and your house and, assets like that, they're gonna take issue. Charitable gifts are considered transfers not made for fair market value. Tithing to religious organizations, expenses that are not in writing, payments to financial agents, and more. So for example, you've got a friend or a family member who's caregiving in home for you, but you don't have it in writing in a proper caregiver agreement. Medicaid's probably going to look on all those payments as transfers made for less than fair market value, and they will assess a penalty for all of those payments. So any agreements that you have, when you're in that stage where you're sort of winding down assets and you may need to qualify for Medicaid, everything has to be proper, above board, and in writing. And all of your agreements have got to be Medicaid compliant. Another thing that comes up with Medicaid a lot is maybe you've got a child living in your home and they're your primary caregiver. Maybe they're not paid, but they live there and you own the home and you want them to be able to stay there. And there is a mechanism for that. But at the end of the day, all of this is very, very complicated. So you need to get legal advice. You need to get legal advice well in advance, especially because you've got that 5-year look back period. And I can tell you that a revocable trust will not protect your assets from Medicaid. And in Colorado, frankly, all trusts are suspect. When Colorado sees a trust and someone trying to, get things into a trust and argue, oh, these are all exempt assets, that's a big bullseye for the organization is HICPUF. And they're going to come after you because they do not like people trying to protect their assets from Medicaid and trusts. So if they can find a problem with that trust, they're going to take it down. Special needs planning and planning for addiction and that sort of thing. Now, on the 30th of September, there is a presentation on special needs trusts. I just bring it up because this is one of those advanced estate planning topics. If you have a beneficiary who is officially disabled, or you believe they will be, that person may need a special needs trust, or we can also call it a supplemental needs trust. It is better if someone else creates that trust for them, either while the other person is alive or in their will, for example. If a disabled person receives an inheritance or anything like that outright, their options are limited and not great. And often they will end up losing their benefits one way or another and then have to requalify, which is just, as if you are in this situation, you know that is an unholy mess and something to be avoided at all costs. I also want to bring up ABLE accounts. So ABLE accounts can be used for people who were diagnosed with a disability prior to turning 26 years old. And if they are receiving benefits, they can have an ABLE account. And ABLE accounts have limitations and some drawbacks, but in some ways, they're a really good tool for a lot of folks who have someone with special needs that they need to plan for. If you've got a problem with a beneficiary who has known addiction problems, or you fear they may lapse back into addiction problems, or perhaps you have a problematic son or daughter-in-law that you are afraid will influence your child and their inheritance more than they should, you probably do want to discuss trust options, and a will can still potentially deal with those issues. But you might want to look at a trust as well. Okay. I'm going to come back to that question. Trusts. I want to talk a little bit about trusts. They're very complicated. They're very confusing to a lot of people. And I want you to know that trusts are not a magic cure-all. Anyone who tells you otherwise is probably selling you something. There are many kinds of trusts, many. I'm not going to go into them. There are a lot of benefits to trusts. Here are a few of them. You can do a lot of things with a trust. They can be very ideal for complex situations. You can maintain more privacy using a trust. Although I will tell you, probate is still a very private process at this point in time. Your spouse cannot change plans as to your assets after your death, which is much harder to do with a will. And there is no probate gap or ancillary probate for out-of-state real estate. When I talk about the probate gap, if you have a will-based estate plan where you have powers of attorney for your lifetime, and then once you die, you have a will. Well, your will can't be submitted for probate for 5 days after your death. And then it usually takes anywhere from a couple of days to a few weeks to actually get your PR appointed. During that time, there is a gap. Your powers of attorney terminated when you died. So your agents can't do much of anything or anything. And until your PR gets appointed by the court, they can't do anything either. There are a few limited exceptions, but they're very limited. So what ends up happening is often family members or your close people end up having to pay out of pocket for certain expenses during that gap. If you've got a trust, there is no gap. Your trustee is your trustee. If at some point it changes to a successor trustee, they step in as successor trustee and they just keep the thing going, okay? And then out-of-state real estate, if you don't have a trust and you own real estate somewhere outside of Colorado, you will have a probate in Colorado if that's where you live. But for your out-of-state real estate, you'll have your PR will have to open an ancillary probate in that state to deal with that real estate. Okay. Now, if you have a trust and you put your out-of-state real estate into the trust, they should be able to avoid that ancillary probate. The cons to trust: there is a higher drafting cost, obviously. There are administrative tasks during your lifetime. As you're changing assets, you've got to decide whether to put assets into the trust or not, whether to just let it sit there. There's a lot to decide. And once you start putting assets in trusts, once you need to change things, it's not usually a big deal. There are trusts all over the place. It can be done, but sometimes there are extra steps, or you have to do something a little bit differently than you would if you owned it outright. Okay. The other problem that I see a lot with trusts is that beneficiaries struggle. If they've got a problem trustee, it's very difficult to get a court involved. So if you have a trust and say you've got 10 kids and one of your kids is trustee and they turn out to not be a very good trustee, it is very difficult for the other kids to get a court to step in and do anything about that trustee. I can tell you, I have a client whose parent passed several years ago. We've been representing them since 2017, and we've threatened litigation and we've settled and we made some progress, but I will tell you that trust is still being administered. I can't tell you why. I don't know why. It isn't complete yet, but it isn't. And that's the kind of problems you can have with a trust when you've got, a friend or a family member acting as trustee, and either they're too busy or they don't understand it or they just don't care or whatever. You can get into some real problems there. Okay. And then I know we've got some questions, so I'm hoping we have a few minutes here.
Yes. Sarah, so we have 2 questions that were typed into the Q&A. The first one is, if insurance stocks car designated beneficiary to the estate, how is that handled when in the will when the items are allocated?
Right. So in those cases, what is going to happen is whatever your will says. So sometimes we do that on purpose, right? Because maybe everyone that you plan to leave things to are all older and you don't want the form to fail. There are a lot of reasons you might do it. Maybe you have minor children and they can't take outright, right? So the asset has to go into the estate or into a trust directly. So it honestly, whatever your will says is what's going to happen to those assets. And that's fine for some assets. Where it gets dicey is retirement assets, because a lot of the time when you designate a beneficiary for a retirement asset, they're all a little different. The rules are different, the penalties are different, but when you have a beneficiary designated, the retirement asset can remain the retirement asset that it is. It can stay an IRA, it can stay whatever it is, and it just kind of rolls over to that other person. And they have the same rights as you, the same penalties and taxes, if they decide to take out money when they shouldn't and things like that. If an account like that rolls over to an estate or to a trust, it may be that the whole thing just has to be cashed out and you can't avoid the taxes and the penalties. Now, some people don't care. I know some parents with minor children and they want the funds to be available to their children. So they don't care. They're like, fine, I'll get more life insurance and whatever, like they just tweak it. But yeah, if your beneficiary designation forms say that something goes to your estate, it's going to go to your estate, and whatever you say in your will is what's going to happen. If you have it set up to go into a trust, same thing. The assets are going to go according to the trust. And if a designation form fails, it's automatically going to go into the estate, and then whatever your will says, that's what's going to happen with it.
Awesome. So our next question, when there's no power of attorney, I understood various foundations can also act as a power of attorney, such as the Boulder Foundation.
I don't know about the Boulder Foundation. I can tell you that most trust banks and trust companies will not act as power of attorney. They will act as your trustee. They will act as the personal representative of your estate. If you need a financial power of attorney, you are going to need to go to one of the professional organizations or firms or individuals that provide these kinds of services. And if that is something that you're considering, like I said, check out Colorado Guardianship Association. If you're using an attorney, ask your attorney. They may be aware of options, and they may be able to give you good questions to ask if you need to interview professionals. So for example, I keep a list. So when people ask me, or if my clients need to find somebody, I give them my list. I have a list for financial and a list for medical. But there are also resources on the Colorado Guardianship Association, where you can, sort by the role. I need to find a financial, professional, or I need to find someone to act as my medical agent. Sometimes people have somebody to do one role, but not the other. So I don't know of any foundations, with the exception of, in a special needs scenario, there is an organization in Denver called the Colorado Fund with People for Disabilities. And they are very helpful with all kinds of special needs planning, and they can serve as trustee, and they can also serve as advisors to trustees of special needs trusts. They are a wonderful resource for special needs planning.
Fantastic. Thank you so much. We have one more pending question. I do want to invite attendees to put any additional questions in either the question and answer or the chat box while we're answering this one, if you have anything burning in the back of your head still. So this one, what is a good way to go about finding a professional fiduciary to be your personal representative if you don't want to use a relative?
Absolutely. And I will say that there are a lot of reasons that people choose to hire professionals. If you have ever been PR or executor of anyone's estate, or if you have ever been a caregiver for someone, you know that it is a lot of work. And sometimes people just don't want to put that work onto their family or their friends. Sometimes they don't have anyone who's able or willing to be in those roles. Sometimes they just don't like their family and friends, or they just don't want them doing it. So the best way to go about it, like I said, is, if you're using an attorney for your estate planning, start with them. They can ask around. Go to the Colorado Guardianship Association to see who the current members are. Reach out to them. I can tell you that I know a lot of the professionals right now are not taking clients. A lot of people are pretty full up. But I highly recommend definitely interviewing at least a few of each. Say you need both medical and financial, but maybe you just need a PR. A lot of the time, if you've got an attorney doing your estate planning, if they do probate as well, your attorney will serve as your PR. That's really common. Most attorneys won't act as your agent under a power of attorney, but they have no qualms with acting as your PR to handle your probate. Otherwise, I say just interview a few people. There are questions you should certainly ask. Think about the things you care about, what your goals are, so that you can ask, how do they go about this? Do they charge an annual fee? How often do they check in with you? How do they know what you want done? How do they operate? What do they have for backups? If they're not a larger organization, what's their long-term succession plan look like? And you also want to look at and ask, if they're bonded or insured. Lawyers, for example, we can get professional fiduciary services covered under our liability insurance. I think CPAs also can. But other people who may not have a professional license, they may not be able to get liability insurance, but they might be bonded, you know. So they're just questions that you want to ask, logistical questions, and you want to find somebody that you feel comfortable with, you know. And honestly, if you think you might need them, not just as your executor or your PR, but also as, you know, a financial power of attorney or medical power of attorney, you might consider starting to use them in a limited way while you still have capacity, so that you can see whether or not you like what they're doing while you still have the ability to do something about it. You know, most people don't do that, but you know, it's an option, and it's a good way to see if somebody's going to be a good fit. Do you have any others, Brett?
Nothing else in the chat. I actually have a follow-up on that just for my own edification.
Sure.
In terms of these different categories of professionals, what are kind of some of the benefits of using an attorney versus a CPA versus a bank versus, yeah.
Okay. So if you're using a trust company or trust bank, you know, they're big, they're not likely to go anywhere, or if they do go anywhere, they're probably being purchased by someone. Hopefully they have decent retention and good institutional knowledge, and, you know, really good auditing systems and processes and procedures. You know, and you know, they're less likely to you know, take all their clients' money and, you know, run off to Tahiti or somewhere. The con with the big banks is they usually want a certain amount of liquid assets, which a lot of people don't have. It just depends on the bank what that asset threshold is. And a lot of them do have very high turnover. So you may have a trust officer that you really like that you're working with, but they may be gone in a couple of years, and you might not like who you get, or, you know, somebody could take over after you can't make any changes. Maybe you've got dementia or something, who's doing a terrible job. And, you know, at that point, there's nothing you can do about it. With professionals like attorneys and CPAs, again, they should be able to be insured, which is nice to know that that's there. And also, you know, they do have expertise in these areas, right? So they understand they understand what their legal responsibilities are very, you know, much more clearly than a layperson. You know, and they have a license to protect. So that there is, you know, there is something at stake for them, right? And, you know, there are other people who are none of these things who do this, and, you know, they may be a great fit too. You know, and I would say if you're going to go with somebody who is not, you know, a bank or trust company or a professional, I would more strongly recommend give them a little work to do while you can still do something about it. And still, you need to ask all those questions. What happens if they get hit by a car? What happens if they decide to quit doing this in 5 years or 10 years? You know, you just need to understand what people are doing and make sure that that sounds like a good fit for you.
Well, thank you so much. This was just fascinating. And even as you were going through this, I know this is elevated estate planning, but there were so many things even in my personal and family life that I recognized. I'm like, oh, that's probably going to happen. That's probably going to happen. That's probably going to happen. So really, really good to be on the lookout for a lot of these things.
Yep.
Yeah, thank you so much for sharing your knowledge and your time and your experience and expertise. This recording will be available in a couple of weeks once it's uploaded to our YouTube channel, which the link for the YouTube is in the chat. Additionally, next Tuesday is Medicare fraud. So please, everyone listening, join us for that. And Sarah, so good to see you, and have a great weekend. And I hope, oh, we have one final question popped in. Oh, a nice thank you. Great presentation from the questions. Thank you. Yeah, so everyone, please have a great rest of your day and a good weekend coming up, and enjoy our nice continued summer weather midway through September. So see you all soon. Thank you. Bye.